What is the 10-day VAWC leave? 10-day VAWC leave is an entitlement for up to 10 days leave with full pay, consisting of basic salary and mandatory allowances, if any. This leave is for all female employees who are victim survivors of violence against women and their children or VAWC. The leave can be used to cover the days that she has to attend to medical and legal concerns. VAWC leave shall be in addition to other paid leaves under the Labor Code and Civil Service rules and regulations. This leave entitlement is provided for, in Section 43 of Republic Act 9262 or the Anti-Violence Against Women and Their Children Act of 2004, and Section 42 of its implementing rules and regulations, or IRR. Workers in the government sector, including local government units, government-owned and controlled corporations and state colleges and universities, are also covered by the guidelines on the availment of the 10-day leave under RA 9262, adopted and prescribed under CSC Resolution 05-1206, dated August 26, 2005. Women employees who are victim survivors of VAWC both in the private sector and the government, regardless of status of appointment, are entitled to this paid leave benefits. The law defines VAWC to refer to any act or series of acts committed by any person, against a woman who is his wife, former wife, or against a woman with whom the person has, or had a sexual or dating relationship, or with whom he has a common child, or the acts are committed against her child, whether legitimate or illegitimate. It can happen within, or without the family abode, which results, or likely to result in physical, sexual, psychological harm, or suffering, or economic abuse, including threats of such acts, battery, assault, coercion, harassment, or arbitrary deprivation of liberty. For the private sector employees, the only requirement is for the victim to present to her employer a certification from a barangay official, prosecutor, or clerk of court, as the case may be that an action relative to the matter, on VAWC, is pending. For government employees, the prescribed application for leave form must be filed, citing as basis, RA 9262. In addition to the application for leave, attach any of the following supporting documents. A protection order is an order prescribed in the Anti-VAWC Act to prevent further abuse of, or violence against a woman and her child. It also provides them relief from said abuse and violation. Any one of the following may also file the protection order in behalf of the victim or victims. Whenever practicable, application for leave must be filed before the actual leave of absence, or immediately upon return from such leave. The certification needed shall be issued for free, according to Section 42 of the IRR of RA 9262. CSC Resolution No. 05-1206, as disseminated through CSC Memorandum No. 15, Series of 2006. Clearly provides that, any woman whose child is a victim of VAWC, as defined therein, and whose age is below 18, or above 18, but unable to take care of himself or herself, shall be entitled to the 10-day leave. The woman employee may avail of the leave benefit in a continuous or intermittent manner. It may be extended, when the need arises, as specified in the protection order. However, an extension beyond the 10-day period shall not be paid since the law only grants a maximum period of 10 days with pay. Extension beyond that period may be charged against the employee's earned leave credits, if she has accumulated some. Availment of the leave benefit shall be at the option of the woman employee. VAWC leave not availed are considered waived. It is neither cumulative, nor convertible to cash. This leave benefit is in addition to other paid leaves under the Labor Code, Civil Service rules and regulations, company policies and/or collective negotiation agreement. Employers, agency heads and personnel, HR managers are presumed to know the provisions of the law. RA 9262 and its IRR, has been published, and circulated since year 2004. The Department of Labor and Employment, has also included information about it in the Handbook, Workers' Statutory Monetary Benefits, while the CSC has issued Memorandum Circular No. 15, Series of 2006, to all agency heads. To ensure that employers comply with the employment-related provisions of the law, the DOL has included a compliance indicator on VAWC leave in its labor laws compliance assessment checklist. A private sector employer who denies the application for leave shall be held liable for discrimination and violation of RA 9262, in relation to applicable provisions of the Labor Code. For the government sector, any official who denies the application for leave, despite submission of accompanying protection order, shall be held liable for conduct prejudicial to the best interest of service. The administrative enforcement of this leave entitlement is considered within the jurisdiction of the DOL Regional Director, for those in the private sector, and the CSC, for those in the government.
This informational video on the 10-day VAWC leave was prepared by the Bureau of Workers with Special Concerns, brought to you by the Department of Labor and Employment. More than jobs. It's decent jobs.